Welcome to The Race. I'm Chance Seals in Washington.
And I'm Ava Joy Burnett. Well, is this a case of a journalist who's gone too far, or does it fall under freedom of the press? Journalist Tim Burke has been indicted on 14 counts, including conspiracy and wiretapping. He's accused of unlawfully hacking a Fox News streaming feed and airing previously unbroadcasted video.
We all saw these videos. They include unaired clips of former Fox host Tucker Carlson interviewing Kanye West. In it, West makes anti-Semitic remarks. Prosecutors say Burke broke the law by using, quote, compromised credentials to access computers without authorization. But Burke's lawyers pushed back, saying in a filing he used publicly available login credentials after a, quote, confidential source provided him with the details.
So we're joined now by journalist Matthew Keys. He was previously charged with the same crimes as Tim Burke and Mark Reichel. He's a criminal defense attorney with more than 3 decades of experience. So, Mark, we're going to start out with you. We want to know, are you committing a crime if you find a login with credentials online and then use that information on a private website? You know, this shouldn't happen if you don't have like those passwords.
It's not yours, but
yeah. So, what do you think about that? Is that an official crime?
Well, the Supreme Court has said it's real simple. Use a gates up or gates down approach. Did the person, the owner of the website, did they have a gates up or gates down approach to you? So if all members of the public were excluded, then you can't access it. If you find this online, you find this anywhere, someone gives it to you. If the gates are down to you or to someone in your position, then it is a crime. But you also have to have some reasonable knowledge that that's how they felt about it, that this is something private or something they would protect. So if you put unique circumstances together, you can't have the occurrence where you come across credentials and you access something like this and it's not a crime. You can't keep the material, but it's not a federal crime if the gates may have been down, but it wasn't obvious they would have been down to you.
But is that just because it's online? I mean, because the government very clearly had a gates up with the Pentagon Papers. No one got charged with a crime for that.
First of all, the computer fraud, the CFAA wasn't around at the time. And secondly, it wasn't prosecuted very much. And that was actually kind of a different scenario. So they can analogize this a lot to the Pentagon Papers, but it's not as close a call as you would think, because here's why. We don't know the facts. We don't know the facts yet. We haven't really been provided any of the evidence. But the allegations the government is making aren't that. They are that they scoured the internet looking for things looking for a way to get into different websites. And then once they found those things, they got in, looked around, find what they felt was valuable or embarrassing and pulled that out and disseminated it. But I will tell you what's really different also is there are several counts. I believe there's about 7 counts altogether. It counts 5 through 14. So there's actually, that's 9 counts roughly 9 counts that are wiretap, just good old fashioned wiretap. Allegations that has nothing to do with computers really, or nothing to do with journalism, that they had a tap somehow, a tap into Fox, and were able to get this intercepted and recorded. And that's good old-fashioned wiretap. So that's the most troubling charge there.
We have Burke here, flying high, successful reporter, what have you. Matthew, you know a thing or two about this. You've been a journalist for a long time, and you shared credentials about a media system. You had to spend 2 years in federal prison. Later on, you got sent back again for another breach. Could you help us understand why a journalist would take that risk?
Well, just to be clear, I've always denied sharing credentials with anyone in any of the cases. I did go to trial and lose the case, and as you mentioned, serve time for it. But I've always said that wasn't me. Having said that, we're really here to talk about Burke. I can't speak to Burke's mindset. I have not met Burke. I've never communicated with him, but I have read what his attorneys say happened, and also what the government alleges happened based on some of the receipts that were in the indictment. And the fact of the matter is that if you're getting a username and password from a source or from anyone else, and you don't have explicit authority to access a protected website, which is what Burke's attorneys, for the most part, have affirmed that he did in this case, that is a CFAA violation, and maybe Mark can speak a little bit more to that. But he's already acknowledged the core conduct of a CFAA violation. And that's going to be really, really difficult to defend against in court. He really has an uphill battle here, and he can frame this as a press freedom case all he wants. But this is really a computer trespass case, and journalists can't break the law in pursuit of journalism. That's the DOJ's stance on this. That's going to be the prosecutor's stance on this. And that's really what the law says, too. You can't break the law in pursuit of journalism.
Well, I want to follow up on that, Matthew. You're saying people can't break the law in the name of journalism, but are you concerned with these high-profile cases that there could be other people who will look at this scenario, look at your scenario? I know you say you've always denied this, but do you think this will give other people the justification to release extremely sensitive information?
Well, like Assange. And
yes, exactly.
You know, if there was a press freedom case to be made here, I think that is likely it. But it's not for the reasons that Burke and his attorneys are claiming. It's precisely what you brought up. You know, I think that the sentiment from the public might be very different if this had been, say, Project Veritas, using compromised credentials to get embarrassing footage from CNN or MSNBC. You know, anybody in the journalism industry is very well acclimated to what Project Veritas did. And I think the sentiment would be extremely different. And what you really have here is somebody who is saying, well, it's okay to break the law if there's some sort of virtuous reason behind it, or if it's in the pursuit of journalism. And, you know, news outlets do have a respected privilege of having their notes, which do extend to raw video footage that is edited out or not released. They have a right to have that protected. And no journalist and no individual has the right to take what's on the cutting board or what's in a reporter's notebook and expose it to the world because they disagree with it, or they think it's good for society, or they think it's virtuous. And in this case, it happened to have been a step too far that likely has criminal repercussions for Mr. Burke.
Wow. That's a really interesting comparison you made. If it were Project Veritas and they went after MSNBC, like how maybe people's lens might be different.
A bit, yeah.
Mark, I did want to ask you about DOJ, though, because we talked about Assange. We have this case with someone, you know, getting Tucker Carlson's videos and embarrassing him online. My understanding is the Attorney General, you know, a top DOJ, has to sign off on pursuing these cases. How do they decide who they prosecute in the media?
Okay, first of all, when they go after lawyers or journalists, it does require upper-level supervisorial sign-off, especially when you use the CFAA. So this computer Abuse Act that we're talking about, the computer crime here, that is so broadly drafted that the DOJ in 2022 came out and said, look, you have to get a real approval of supervisors very high up before you charge someone. And additionally, you have to actually consult with an expert within the DOJ to see whether or not this furthers a federal interest. And that is to protect trade secrets, national security, and things like that. Extremely important items, not just Facebook data and so forth. Now, in this case, it's a journalist that also in the DOJ manual, the U.S. Attorney's manual, when you want to go after a journalist in any way, that does require a lot of discussion, you know, high up. I don't know if it requires the acting deputy attorney general, but probably the highest ranking attorney general in the state of Florida for the federal government is probably required to sign off on this. And it's something you touched on. When they did do the search, remember, a search warrant isn't proof of a crime. It's reasonable cause as a crime. Here they got the search warrant and took everything from his newsroom. They took everything. It's the same as if they came to your newsroom and took everything out of your newsroom. Everything. All of your phones, your notes, your notebooks, your everything, your computers and so forth, and then went through that to see if this crime, they could prove this crime they were investigating. That's the big deal. This is a very broad search of a newsroom, and they've kept it for the last 2 years. That's something that's a little, you know, the process is just as frightening as a substantive charge.
It's a very delicate balance, and we thank you both for being here to give us both sides of the story. Really great conversation. Matthew Keys and
Mark Reichel, thank you so much.
Thank you so much for being here with us.
All right, coming up next on The Race, really interesting conversation there. I'm glad you have your legal background, too. That's very helpful.
Listening in a different way.